still one of the largest problems for lawyers. Big law firms, small law firms, sole practitioners, it doesn't matter. Cuts across all size of law firms is collections. Lawyers are not effective yet in collecting all that they bill. And that surprises me. I guess that's why I was asked by the American Bar Association to write my book, Collecting Your Fee, Getting Paid from Intake to Invoice. What's not discussed, however, is something equally as insidious, if you will, if that's the right word, and that is the write-downs and write-offs. Most lawyers feel guilty about all the time they spend doing the research and hand-holding with clients and negotiating with adversaries that they write down their time. And that, of course, presumes that they're billing based on the hourly rate, something that is in question more and more as we move forward. But most lawyers still today use the hourly billing rate as the primary modality for billing. And so now, if you write down the amount of time that you use, that you expend for a given client matter, the client doesn't even know it. They're not even getting the bill because you've written it down before the bill is sent out. I know that a number of folks have suggested that you show all the time that you bill and then just write NC. The theory goes that if you write NC, at least the client will feel better. They know you've expended the time and energy and creativity, but they also know that you're not charging them for that segment of it. I think that that was probably a good idea with some small amount of time. It's sort of like not charging for postage or not charging for fax or not charging for long-distance calls. But if you're talking about a large block of time, which is what I'm raising here, to write a NC sort of, in my mind, tells the client, well, you didn't really know what you're talking about. You're charging them or at least showing time expended for your learning curve. One of the niceties from the perspective of the lawyer is that law is intellectually challenging. And what that means is that almost everything we do is new. And if it's new, we have to do some research. If it's research required, there's a learning curve. To say anything but that would mean that when we come out of law school, we come out as a fully cooked cookie. And everything we do is cookie cutter and replicable, and therefore we should have a fixed rate for it, or we ought not have to do any research. Well, that's just not the way it works. And therefore, clients ought to be happy to pay for our learning curve because we're going to be better equipped to address the challenge that they have, that they've brought to us. Now, if it is something that is more what I would call a commodity type practice, we can develop a fixed fee. And then everything along that line, for example, an M&A agreement, an IPO document, should be the same price, $250,000 or whatever the price might be. And that because it's so standardized, we can use technology to make our efforts more efficient. And therefore, the client doesn't have to worry about the learning curve. Any learning curve that we do improves the efficiency that we bring to the table, and any efficiency that we bring to the table enhances our profits, and all those increased profits redound to us, not to the client. Well, that works in certain areas. And we can get into that later when we have a discussion about alternative fees. To some extent, we've already talked about that. But when we're charging based on the hour, it is unrealistic for us, and it's unrealistic for the client to assume that there's not a learning curve involved. Therefore, why should we write that down? I suggest we don't write that down. The next area is the idea of the write-off. Here, we've sent the bill out, but for some reason the client's not paying the bill. And so rather than sue the client for a bill that is legitimate, for work that was legitimately performed at the request of the client, we choose merely to write it off. And when we write it off, that impacts our realization rate, meaning that instead of collecting 100% of what we bill, we're going to collect something less than the 100%. It seems to me that the realization rate for law firms can and should be higher than it currently is on average. There has to be collection policies put in place. There has to be modalities for addressing client issues to make sure that there is no legitimate dispute between the lawyer/law firm and the client, which is the cause for them not paying the bill. Once all consideration of dispute, or once all consideration of misunderstanding is alleviated, then the choice is to the lawyer. Do we sue or do we not sue? Obviously, there's no reason to sue a company that's no longer in business or can't afford it. But it seems to me that lawyers ought to think more and more seriously about suing a client who won't pay for no apparent reason. Take a look at my book, Collecting Your Fee, Getting Paid from Intake to Invoice, to look at the scenario, the script that I've created that will help you address whether the client can afford to pay, whether there is any dispute in place between you and the client before you make that decision. But once all else is removed from the table, just to write it off, because insurance companies say clients are going to be adversely impacted because clients, instead of paying you, will file a counterclaim for malpractice, seems to me to miss the point. Most of these issues, in reality, can be addressed at your very first intake meeting. And that's why I suggest that both for the perspective of finding the script that you should use with your client, as well as to reduce your exposure to the need to write off a legitimate bill, you take a look at my book, Collecting Your Fee, Getting Paid from Intake to Invoice. Then, if you have any questions, don't hesitate to call me. Thanks.